We can analyze today an example of having a set of 6 questions on the exam, out of which you shall answer 3. These are very common topics that usually come up either as a problem or an essay question. Sexual offenses, offenses against the person, property offenses, homicide offenses. Firstly, sexual offenses is most commonly come up as a problem question on criminal law exams. It could be also offenses against the Persons Act. I have seen it as an essay question as well as problem question, but more common is for it to come as a problem question. Property offenses, also very common topic of examination, and homicide offenses. If you have an exam in criminal law, I suggest you revise all these 4 topics. Before we go to discussing the topics that we just mentioned, I'd like to remind you about a problem question style, because criminal law most likely you will have to do a lot of problem questions, and it's very important that you know how to answer problem questions. Yeah, so problem question style, you need to start with the issue, identify the legal issues, and then you need to say what are the applicable laws, whether it's a case or a statute. You need to identify it and define it. What is the actus reus and mens rea of the offense in question? And whether, if it's a common law offense, you need to say the case. And if it's a statutory offense, you need to say the statute and identify what is actus reus and mens rea. After discussing the law, you have to apply it to the facts of the case. Application and analysis is the hardest part, where most of the students lose marks. So make sure that you do it right. You need, every time you discuss a new offense in actus reus and mens rea, you need to make sure that you clarify to the examiner that you understand the law and you are able to apply the law to the facts of the case. And at the end, you need to make conclusions, like small conclusions after the discussion of each offense, to say what would be the most likely outcome. Will the party that you're advising be charged of the offense? What is the likelihood of that? Obviously, you cannot give definite answers. Law is not math where there is one definite answer. Law, it gives you many possible answers. So your job in a problem question or essay question is to give all possible answers, make assumptions. The problem question will not give you all the facts. So a lot of things you will have to assume, and you just need to make sure that you clarify what are all possible outcomes from the facts of the case that has been given to you. We'll start revising with Sexual Offences Act. Section 1 is rape. Section 2 is assault by penetration. Section 3 is sexual assault. Section 4 is causing a person to engage in sexual activity without consent. And Section 5 is statutory rape or rape of a child. So the statute differentiates a rape of an adult from a child, and make sure that if you see a rape in the problem question, make sure you understand if it's of an adult or a child, and then apply the relevant statute to it. The most important in criminal law sexual offenses is that you understand the consent element, because this is the most difficult one. After identifying what is the most relevant section from the Sexual Offences Act, you need to apply Section 75, 76, or 74 to discuss whether or not there was a consent. So this is the most important element. If the victim consented, then that is a defense, unless it was a minor. There is Section 75, 76 consent, evidentiary presumptions of non-consent. So there are certain circumstances in which the presumption will be that there was no consent. However, it will be upon the defense to show, to rebut the presumption and show that there was indeed consent. So if any of these circumstances, the presumptions apply under section 75, you need to say so, and then you need to make arguments whether or not there is anything you could argue to rebut that presumption. Section 74 is a general definition of consent. According to section 74, Sexual Offences Act 2003, a person consents if he agrees by choice and has the freedom and capacity to make that choice. You need to then apply this to the facts of the case and discuss if the party you're advising consented to the sexual act and did it by choice. This means if he was influenced by some external circumstances, like if the person was drugged or if the person was drunk, that could be making it questionable. If the consent was by freedom and capacity and choice, so you need to make sure that you discuss all of those considerations. When applying these provisions in an exam question, it is essential to always begin your analysis with the evidentiary presumptions. You should only discuss section 74 if the circumstances in section 76 or 75 are not present. It is also important to mention the cases that came before the Act, the 2003 Sexual Offences Act. So how do you answer a problem question on sexual offences? You need to first identify which is the most relevant statute section from the Sexual Offences Act 2003. Then you need to discuss what is the actus reus and mens rea of the offence. Apply the relevant cases, if any, and discuss consent element under section 76, 75, or 74. Example problem question. Discuss the offenses and defenses arising in the following scenarios. After 2 weeks in isolation, Hannah wants to see her boyfriend, John. One night, she sneaks into John's flat. She's wearing a big fur coat and she crawls into John's bed, hoping that he will think she's his dog, Oscar, so won't kick her out. He indeed assumed she was his dog without fully awakening. This is just an extract from our example problem question on sexual offences. It's a first-class answer, so I suggest that you have a look at it on our website to see it in full, but we will discuss the extract, the first part of it now. You can only use our example essays for educational purposes. You cannot copy it. If you need help, personalized support, you should book a tutoring session. The question is consent with sexual assault. Actus reus, as we said, first thing to do is to establish what is actus reus and mens rea and which of these sections apply. Actus reus of sexual assault is sexual touching without consent. Mens rea is intention of touching without reasonable belief that victim consents. Touching is sexual when a reasonable person would consider that the nature of touching is or may be sexual in the given circumstances and considering defendant's purpose in relation to it. Now, when we have defined what is sexual assault, we can apply it to every single scenario. There were a couple of scenarios about sexual assault, so it is a good practice that you define what is actus reus and mens rea in the beginning, so you don't have to repeat defining what is sexual assault every time you have to discuss it in regards to the new factual scenario. Potential liability for sexual assault arises when Hannah wears a fur coat in John's bed to make him think that she's his dog. The fact that Hannah is in John's bed can be characterized as sexual touching because a reasonable person would consider that the act of going into somebody's bed and curling up against him could be sexual in nature. And Hannah is desperate to see her boyfriend. So the way she's behaving seems to be a sexual act. Thus, actus reus is most likely met, but the consent of John as to the sexual act could be rebutted. And then you need to discuss on what grounds the consent can be rebutted. Section 76 states that it is to be conclusively presumed that there is no consent if the defendant intentionally induced the complainant to consent to the relevant act by impersonating a person known to the complainant. In Albuquerque, defendant impersonated the victim's boyfriend and had sex with her, which was held to be an active deception. So as you can see here, we're identifying not only the relevant section for consent, but also a similar case. If you can find a case that resembles on the facts, the problem question that you were given, make sure that you mention it. Similar cases should be mentioned. Probably you've heard that you should only be mentioning principles from cases, but if the case is, if the facts of the case is relevant to the argument that you're making, you should also mention briefly the facts of the case that you're applying, only if it is relevant to the argument you're making. So here it was relevant. That is why we mentioned the facts, because the facts were similar. So we're saying that in a similar case where something like this happened, the court said that it was active deception. Similarly, Hannah made John think that she was his dog, which would be an active deception, applying the case of Albuquerque. Both Section 76 and Albuquerque refers to impersonating a person known to the complainant, but this principle could be extended to impersonating pets as well, because the objective is the same, impersonating a living being known and loved by the complainant. Section 75 is a set of evidential presumptions to prove lack of consent. As you can see, this answer shows a very good understanding of what is Section 76, 75, and relevant case law, and successfully applies it to the facts of the case. That is why it was awarded a first class. So make sure that you understand what is the law and apply it to the facts of the case and give proper analysis. Homicide offences is the next topic of discussion. Homicide offences can be murder, but not only murder, there are also manslaughter offences, and there are different kind of manslaughter offences: voluntary manslaughter, involuntary manslaughter. Actus reus of murder is unlawful killing of another person under queen's peace. Mens rea of murder is malice aforethought, as defined by Koch. So you make sure that you mention first, with every offense that you're discussing in criminal law, you have to mention what is actus reus and mens rea. And then if there are any defenses that the defendant can rely upon. If there are any defenses, it could be voluntary manslaughter or involuntary manslaughter. Or if there are full defenses, then that means no liability if it's full defense. Voluntary manslaughter, it has the same actus reus and mens rea as murder, but also satisfies the element of partial defense. So there are the partial defenses as well for murder, which is not the case for other offenses. Loss of self-control, diminished responsibility, suicide pact of partial defense is also, all three are partial defenses. You need to have a look at Section 54 and 55 of Coroners and Justice Act to see what kind of loss of self-control is recognized under this section. And diminished responsibility is when defendants recognize medical condition led to an abnormality of mind, but depends on if the abnormality of mind substantially impaired her capacity of thinking or totally. If it was totally impaired her capacity of making judgment, then you could consider insanity defense, which is the full defense. Involuntary manslaughter. So involuntary manslaughter requires actus reus of murder. You need to discuss that if there is actus reus of murder, so if there was unlawful killing of person, and then establish that there was no mens rea of murder, and then see if there were any partial defenses, or in case of involuntary manslaughter, if any of the any of this unlawful act took place, or gross negligence or reckless manslaughter, if any of this apply. Unlawful act is when there is a base offense, an unlawful act, which could be, for example, drink driving. If someone kills a person during driving when in drunk state, that could be unlawful act manslaughter, because there was no mens rea to kill someone, but someone died, but unlawful act was committed, which was drink driving. Gross negligence manslaughter is usually applies to medical cases when, because of medical negligence, somebody died. Reckless manslaughter is when somebody was reckless and as a result of that, somebody died. Offences against the Persons Act is also a very common topic that comes up on criminal law exams. You need to know assault and battery. This is any conduct by defendant that intentionally or recklessly causes victim to apprehend imminent unlawful personal violence. The difference between assault and battery is that assault does not require physical touching, whereas battery requires physical touching. It is a conduct which intentionally or recklessly inflicts unlawful personal violence, whereas in case of assault, it causes victim to believe that unlawful violence will be inflicted upon him. There are cases that you need to know about this. Ireland, Venna, Spratt. Make sure that you have a look at our notes where we explain all these cases and what you need to know from them. It's the most important to know about SimpleStudying is that we do not give too many details that can confuse you. We just try our best from our own experience to give you just what is required for you to know to get the highest grades. Offences against the Persons Act 1861 is assault occasioning actual bodily harm. This is satisfied when defendant commits an assault or battery that causes victim to suffer actual bodily harm. Maximum sentence for this is 5 years. Assault or battery with suffering habeas can be section 47 liability. You need to clarify what is actus reus and mens rea of section 47 and then apply it to the facts of the case and conclude whether or not it could be actual bodily harm. So if the harm inflicted upon the person is a bit more serious, you could consider applying wounding, section 20, wounding or inflicting grievous bodily harm. Grievous means serious. Malicious wounding or inflicting serious bodily harm with at least foresight of some bodily harm. It is also 5 years of imprisonment, which has been criticized because this is more serious offense than section 47 and have maximum sentence of 5 years for both can be controversial. You need to, again, clarify what is actus reus and mens rea stated in your essay and then apply it to the facts of the case. Mens rea is acting maliciously, intentionally, recklessly, whereas for section 47, the mens rea would be to commit to inflict some harm. Section 20 does not require defendant to intend or foresee the full extent of the harms, but just some bodily harm would be enough. This was explained by Diplock in Mowat. Make sure that you cite the relevant cases when you explain the actus reus and mens rea, if there are any cases that is relevant to the argument that you're making. Offences against the Persons Act also has another offence that you should be aware of, which is section 18, wounding or causing serious bodily harm with intention. So this one has intention to cause serious bodily harm, and usually the sentence for this offence is a lot higher. Actus reus of section 18 is identical to section 20. So the physical act is the same, but the difference is in intention. intention to cause serious bodily harm to any person, or with intent to resist or prevent the lawful apprehension or detention of any person. That could also satisfy the mens rea requirement. Have a look at the case of Taylor for more information. Now I'd like to tell you a little bit more about how we can help you. We're a team of students and graduates in law who have gotten high grades, and we have created simple study materials focusing on high grades for you. We have simple notes, example essays, tutorial videos, quizzes, flashcards, full of exam tips. We are trying to be more practical and give you just the right information that we use to get high grades, so that we share the insider information. How did we do it with you, so that you can have the same success as we did. If our resources are not enough, I highly recommend you to have a look at our tutoring services. We have already helped thousands of law students to get high grades. Our regular students usually get a first class, as you can see on the reviews. If you want to be the next student to get high grades, please join SimpleStudying now. You can use the 10% discount code offered this month. If you enter the code May 2022, you should be able to apply this code. Thank you very much.